Okay, good afternoon, everybody. Our eminent speaker of the day, Mr. Gautam Bhatia, Principal of the College, Dr. Mrs. Syria, Head Department of Law, Dr. Menon, Principals and Directors of various universities and colleges of law, my worthy colleagues in my own department, members of the teaching faculty from different law colleges and law universities, and young student friends. A very good afternoon to all of you. I deem it a great pleasure to welcome all of you this fine afternoon at this webinar, which is being hosted by the Center for Constitutional Law and Public Policy of the Department of Law of Dr. Ambedkar College. Friends, this is a webinar this afternoon that hosting on a subject of great contemporary relevance, and that is transformative constitutionalism. The present times has given a great currency to this phrase of transformative constitutionalism, and we see that there is enormous enriching literature that is being generated. We see this phrase being used on and off in the judgments of the Supreme Court itself, in the speeches given by various judges of different courts across the country, especially if we look at Justice Chandrachud's judgments and the speeches that he has delivered. He very emphatically talks about the transformative nature of our Constitution. So perhaps it could be the case that our Constitution has always been transformative, but it is that we come to talk about this idea in the present times. So when we decided on holding this webinar or hosting this webinar by the Department of Law, we fixed upon this particular topic of transformative constitutionalism, given its contemporary relevance, and we thought that it would be a very meaningful, discussion and deliberations that we have on this particular subject. And I'm sure all of you would agree with us that, when we talk of transformative constitutionalism as a subject to be taken up for discourse and discussion, probably the first, one of the first names that comes to our minds is the name of Gautam Bhatia. And I'm extremely glad that today, for this webinar, we have as our eminent guest speaker, Mr. Gautam Bhatia, who was very kind enough to give his consent for being a part of this webinar as the chief speaker today. I think, a great share of credit in terms of popularizing this whole idea of transformative constitutionalism certainly goes to Gautam Bhatia, because the excellent monograph that he has offered on the transformative constitution, I have myself read that book authored by him, and the incisive analysis that he makes of the judgments of the different courts, and the very, very powerful arguments that are fostered by him in the simplest possible language. All these factors make his book indeed a very, very compelling read for all of us. So I'm indeed very, very grateful to you, Gautam. Thank you very much for having agreed to be a part of this webinar. On behalf of the Department of Law of Dr. Ambedkar College, I once again take the privilege of welcoming you here. Thank you very much.
Thank you.
Friends, I was myself part of one webinar yesterday, and the moderator spoke, I think, is something that I would want to echo with equal emphasis today also, that there is probably a very limited yet a very, very powerful reason for us to be actually grateful to COVID-19 in one sense. Because had it not been COVID-19, I think even the idea of getting Gautam Bhatia from Oxford down to Nagpur to address us on this topic would have been something certainly very difficult, if not impossible. So I think it's just that we've been able to get in here, the speaker today, but also the advantage that we have so many people from different parts of the country who have signed up for this particular webinar and who actually take this opportunity of being a part of this great discourse. So I hope going ahead is going to be a very fruitful time for all of us. Ladies and gentlemen, as the moderator of this particular webinar, let me quickly put forth a certain things for all of you here. Firstly, I feel very happy to put on record that an overwhelming registration of 1,000 plus people registering and signing up for this particular webinar. But we have deliberately kept the number of people into the Zoom meeting room very, very limited in order to be able to manage everything undisturbed. So one, protocol that we everybody to follow, particularly for those who are into the Zoom meeting room, kindly ensure that your microphones and your video cameras are switched off for the entire duration of the talk. We are having other participants in this webinar live on YouTube. At the end of Gautam's talk, which would range for around 40 to 45 minutes, we're going to have this platform for a question answer session. Those who are viewing this webinar on the YouTube, we request you to please put your questions in the YouTube chat box so that them in the question answer. All of you who are in the Zoom meeting room, we request you as well to put questions in the chat box, or if you want to have that opportunity to directly pose the question to the speaker, we could have done that for some of you. So this is just a part of the small protocol I wanted to specify. And with this, I think we could directly be taking this webinar ahead. And as we begin, I would call upon the principal, Dr. Mrs. Syria, to deliver the welcome address, please. Over to you, Dr. Syria.
Thank you, Varsha Madam. Ladies and gentlemen, a very good afternoon to one and all. Today, I am very happy to welcome you all to this national webinar. And it's my proud privilege to brief you all about my institution. Dr. Ambedkar College, Nagpur, founded by the visionary late Padma Shri Dada Saheb Gaikwad in 1964 and is affiliated to Rashtrasanta Tukdoji Maharaj Nagpur University, Nagpur, is indeed a time-tested center for higher learning. Ladies and gentlemen, we are all aware that Dr. Ambedkar College, run under the aegis of Paramapuja Dr. Baba Saheb Ambedkar Smarak Samiti, is situated in the sprawling premises of Holy Diksha Bhumi, which is the historic place where Bharat Ratna and the architect of Indian Constitution, Dr. B.R. Ambedkar, embraced Buddhism. With a modest beginning in 1964, the institution now has 56 glorious years of experience in imparting quality education in the faculties of arts, commerce, science, law, and management. With its uncompromising standards of excellence, our institution believes in imparting, man-making, character building, and value-added education. The reaccreditation of the college as A grade by NAC and the status of college with potential for excellence conferred by the UGC bears eloquent testimony of its unshifting commitment to quality. Dr. Ambedkar College is truly a college like none other, and it is not surprising that it has won a very special and unique place in the academic, extracurricular, and sports landscape of Nagpur city, Vidarbha region, as well as in the central India. The strength of college students is approximately 5,000. Ladies and gentlemen, we have assembled here for the one-day national webinar on Transformative Constitutionalism, which is organized by the Department of Law of a college. I, Dr. Mrs. Pratibha M. Syria, Principal of the college, welcome all the delegates, participants, and research scholars for this national webinar. I would like to extend my warm welcome to the eminent resource person of today's national webinar, Mr. Gautam Bhatia, a well-known Supreme Court lawyer. I'm sure that today's webinar would be very informative and beneficial to all the participants. I appreciate the efforts taken by our faculty members, Dr. Mrs. H.V. Menon, HOD Law, Dr. Varsha Deshpande, Dr. Sandhya Kalamdhad, Dr. Pratima Lokhande, Mrs. V.A. Sukhdeve, Ms. Shilpa Rathod, and Ms. Shazia Bari for organizing today's national webinar. Once again, on behalf of Dr. Ambedkar College, Diksha Bhumi, Nagpur, I welcome you all. Thank you. Thank you, Varun. Over to Dr. Varsha Deshpande, madam.
Thank you very much, Dr. Syria, for your warm words of welcome. With this, ladies and gentlemen, may I now invite the Head Department of Law, Dr. Mrs. Hema Menon, to deliver the introductory remarks, please. Dr. Hema Menon.
Good afternoon to one and all. It's a pleasure that we have with us today principals, vice principals, and directors of various law colleges, faculties from different colleges, and students from the law fraternity.
Hey, unmute yourself.
A pleasant afternoon to one and all. It is a pleasure that we have with us today the principals, It is a pleasure that we have with us today principals, vice principals, directors, and faculty members from different law colleges and the students from the law fraternity joining us in this one-day national webinar. These are extraordinary times, and at Dr. Ambedkar College, Diksha Bhumi, we are committed to continue the teaching learning process in spite of any odds. The college has undertaken the task of reaching out to students and faculty with contemporary issues through webinars in different faculties during this period of lockdown. I, Dr. Hema Menon, with my worthy colleagues in the Department of Law, feel satisfied that this webinar on the topic of transformative constitutionalism has come to the stage of fruition today, as it shall be discussed by one of its eminent exponents, Dr. Gautam Bhatia. I thank you, Dr. Gautam Bhatia, for accepting our invitation to be the resource person today. Coming to the topic, the Supreme Court in the Nalsa judgment said, and I quote here, the role of the court is to understand the central purpose and theme of the Constitution for the welfare of the society. Our Constitution, like the law of the society, is a living organism. It is based on a factual and social reality that is constantly changing. And here I unquote, it is intrinsic, therefore, that the purpose of the Constitution is to transform the society for its betterment. From this perspective, the school of thought, which says that our Constitution was transformative from its very inception, has to be given weightage because when India achieved independence and thereby adopted this Constitution, it was obvious that the need of the hour and of the society with its deep structural inequalities as it then was would have to transform itself for betterment. The trinity of liberty, fraternity, and equality could best be established and protected only when the Constitution fulfilled this rule. A country like ours, which is fighting bigger internal enemies like socio-economic inequality, extreme poverty, gender discrimination, etc. It is India as it was, and it continues to be plagued by issues of injustice, discrimination, etc. Recent judgments of the Supreme Court have been vocal in declaring that transformative constitutionalism is one of the objectives of adopting the Constitution itself. This precept and notion in its variant application is the topic of exposition in today's webinar by our eminent speaker, and I'm confident that this shall be an intellectually stimulating hour for all of us engaged in this webinar. I thank all the participants for their enthusiastic response to attend this webinar. I thank all my worthy colleagues in the department for coming together to put up this webinar so that we can all enjoy this hour of intellectual stimulation. I thank you all. My best wishes to everyone to stay healthy and safe and to have a lovely 1 hour ahead. Thank you.
Thank you very much, Dr. Menon, for those introductory remarks. Ladies and gentlemen, as we move ahead, before I invite Mr. Gautam Bhatia for his address, I have the privilege of introducing him to all of you. Though for all of us, no doubt, Gautam Bhatia is a familiar name. Nonetheless, let me introduce all of you quickly to his illustrious career graph, which he has been able to achieve at a very, very young age indeed. Gautam graduated as a topper from the NLSIU in 2011. Thereafter, he had the rare honor of becoming a Rhodes Scholar and moved to Oxford to complete his BCL from there in 2012. He did his MPhil again from Oxford in 2013, LLM from the Yale Law School in 2014, and in 2018, he got himself registered as a DPhil candidate from Oxford under the supervision of Professor Sandra Fredman, which project he is likely to complete by July 2021. Just 1 year after he graduated, that is in 2012, he became the recipient of the Herbert Hart Prize for writing the best essays in the Jurisprudence and Political Theory examination, awarded by the Faculty of Law, University of Oxford. In 2017, he was awarded the National India Fellowship for writing his now popular monograph on Transformative Constitution. Apart from his book on Transformative Constitution, which is no doubt, as I already said, a very compelling read, he has also authored another book titled Offend, Shock or Disturb: Free Speech under the Indian Constitution. And what I must notably mention here is that his book has been cited by the Supreme Court of India, the High Court of Kerala, and also by the High Court of Madras a couple of times. This fact, which is no ordinary feat, ladies and gentlemen, speaks volumes about the profundity of his scholarship. The list of his publications as articles and chapters in edited books on wide-ranging subjects in the public law regime is overwhelmingly impressive, but if I may also add, this is indeed too long to allow me to mention it, particularly when I'm bound by the limitations of time. Gautam Bhatia is the founder and editor of his very popular blog, Indian Constitutional Law and Philosophy blog since 2013, which also has been cited by the Supreme Court of India in Navpreet Singh Johar, by the Bombay High Court, and also by the High Court of Jammu and Kashmir. Apart from this, his writing titled Surveillance and the Right to Privacy in India, a Constitutional Biography, which was published in the National Law School of India Review, has been cited by the 9-judge bench of the Supreme Court of India in Justice Puttaswamy versus the Union of India. His prestigious research engagements include project coordinator on challenging the constitutionality of hanging as a mode of capital punishment in India, organized by Oxford Pro Bono Publico, pro bono legal research for I Pro Bono on contempt of court proceedings initiated by the Bangladesh Supreme Court against the human rights journalist David Bergman. Research and writing assistance via Oxford Pro Bono Publico for the American Civil Liberties Union, general comment, privacy rights in the digital age. Gautam Bhatia is a highly sought after person today for delivering lectures and talks. But what is noteworthy is that at a very young age, he has been invited as a panelist at Penn International's side event at the 38th session of the United Nations Human Rights Council, Geneva. He was invited to deliver a lecture on obscenity, hate speech, and freedom of expression in India, delivered at ITAM Mexico City. Panelist at the workshop on international freedom litigation organized by the Media Legal Defense Institute, Bangkok, in 2014. His work experience as a legal professional is also enviably impressive. He was a prominent part of the team that acted for the Republic of India in an international tax dispute at the Permanent Court of Arbitration, which matter was argued at The Hague in August 2018. As an advocate, he was associated with various prominent cases, like the one that involved the constitutional challenge in the Article 370 case, the challenge to the internet shutdown in Jammu and Kashmir, the constitutional challenge to the Citizenship Amendment Act, and the review petition against the Supreme Court's judgment on reservations in scheduled areas. As an advocate in the chambers of C.U. Singh, Senior Counsel, Supreme Court of India, he was associated with prominent cases like, for example, the 9-judge bench decision on fundamental right to privacy under the Constitution, the 7-judge bench decision on the scope of presidential ordinances, the 5-judge bench case on the constitutionality of Section 6A of the Citizenship Act, the national anthem case, and the constitutional challenge to India's biometric identification system, that is the Aadhaar. Ladies and gentlemen, there could be a lot more that one could talk about Gautam Bhatia, but one reason why I thought that at least giving these prominent things, among others, about his career is especially for the young student friends who are watching or viewing this webinar today, because I think Gautam Bhatia's journey presents a wonderful example for so many others to emulate in their own lives. With this introduction, I now hand over this platform to you, Gautam Bhatia. Gautam, can you take over, please?
Yes, thank you. Am I audible?
Gautam, I think you need to unmute yourself.
Yes, I've unmuted. Am I audible?
Okay. Okay.
I'm audible. Okay, good. Dr. Deshpande, thank you so much for inviting me to deliver this talk and for your very kind introductory words. Sorry, am I audible? Is it fine?
Yes, please.
Okay. Dr. Deshpande, thank you so much for inviting me to deliver this talk and for your very kind introductory words. Dr. Syria, Dr. Menon, respected principals and professors of law, colleagues at the bar, research scholars and students, thank you all for having me here. It's a special privilege to be talking about the Transformative Constitution at the Department of Law, Dr. Ambedkar College, Diksha Bhumi, Nagpur, because not only was, of course, Dr. Ambedkar the head of the drafting committee responsible for putting the ideas of the framers of the Constitution into actual concrete legal language, but a significant part of the transformative nature of the Constitution bears his imprints, along, of course, with many others. It was a deeply collaborative enterprise, the framing of the Constitution. But there's one specific thing about Dr. Ambedkar that I think really brings to bear this whole topic of transformative constitutionalism that we are talking about. So if you take up the 6-volume series on the preparatory materials around the framing of the Constitution that Shiva Rao has collated, that famous 6-volume series. Now that 6-volume series has a number of documents, discussions in the committee, all the work that went into the framing of the Constitution before the final draft was debated in the Constituent Assembly. Now, and therefore that's a very fascinating collection of papers and documents. And in volume 2 of that series, between the pages of 99 and 103, there is a very small document. It's called Notes on Fundamental Rights, and it's authored by Dr. Ambedkar. This is his idea of what a chapter on fundamental rights in a modern constitution should contain. And it's a very brief document. It's worth reading. And And what he envisions in that document is the way in which the Indian Constitution makes a break not only with the past, but with the dominant understanding of what constitutions are meant to do. And what he points out is that if you look at the history of the framing of the constitutions across the world so far, what you find is this belief that if you control the power of the state and the government, if you limit and place constraints upon what the government can do, then what is left over is individual freedom. So freedom consists in being free from government action, state action. That's a very classical understanding of freedom. Dr. Ambedkar says that this is an incomplete idea of freedom. And he says that if you look at the way the Industrial Revolution has taken place, if you look at the way that the economy functions at this time, and this is back in 1947, he says that the dictatorship of the state is one thing, and of course, fundamental rights must protect individuals against that. But he also says that it is equally important to avoid the dictatorship of the private employer. And for that reason, he insists that there must be a series of fundamental rights that protect the interests of labor, whether it is the right against forced labor that finally enters the Constitution, or whether it is the right to a minimum wage that was interpreted by the Supreme Court in 1983 in the PUDR case to be part of the right against forced labor. And so he says that this has been the dominant way of thinking. We must break with that. We must understand that threats to freedom, to equality, to fraternity are as powerful when they come from what we think of as the private sphere as when they come from the public sphere, the state. And so his idea of constitutionalism was a constitution that has a much richer, deeper, and more powerful understanding of what freedom is than what was traditionally believed, that, okay, the state can't do some things to you, and if the state cannot imprison you without cause, if the state can't censor your speech, then you're free. So Dr. Ambedkar said, no, that's not enough. There has to be more to this idea of freedom. And in that sense, he was far ahead of his time. It was only constitutions that came after him, much after him, that this idea really took root. And so that gives you a sense of the far-sighted vision of transformation that formed the basis of the framing of the Indian Constitution, and that's something that we'll come back to. And so that's the framework within which I want to think about some of these issues. Now, in the last few months, there have been many constitutional disputes that have taken place in our country. Some of these are presently pending adjudication in the Supreme Court and in other courts. But if you look a little deeper into these disputes and ask yourselves what is at the root of these disputes, what is the basis of these disputes, you'll find a set of ideas, principles, values. So let us take, for example, the ongoing controversy regarding the alteration of Article 370 of the Indian Constitution. Now, people have different views on the desirability of something like Article 370. And that is a political debate that has been going on for many, many decades and is still going on. That political debate is not in question at the Supreme Court because it is not a legal issue. What is in question is the process by which this alteration took place. So the question is that at a moment at which the Legislative Assembly of the erstwhile state of Jammu and Kashmir had been dissolved and was not in existence, could a change of this character that permanently altered the underlying structure of the state be brought into force at a time at which the parties involved did not include the representatives of the people of that state. That's one key question. Another key question is that, was the consent of the president enough to bring about this kind of a change in a federal context? So if you think about it, the real issue before the court is not whether it was a good thing or a bad thing to alter Article 370, whether it was politically needed or not. The question is that, was it done in a manner, in a way, and through a process that conforms to what the Constitution requires? Similarly, in many of the debates around COVID-19 that has become a staple feature of our conversation over the last 4 or 5 months, there's been a debate about the entire federal relationship between the states and the center with respect to the question of distributing finances, distributing aid. Which of the government should have ultimate control over regulations involving the movement of people, the opening or the closure of industries, the sealing of state borders, and so on? And one central feature of this debate, again, it's not that COVID-19 needs to be tackled. We all agree that it does, and it requires far-reaching measures to do that. But the question is that, given the federal structure of our polity, what should the center be doing and what the state should be doing? And to really answer that question in these unprecedented times is to go back to the basics. Why is it that we have a federal constitution? What is the value that federalism serves? Accountability, responsiveness, and so on. And given that, how should we understand the far-reaching legal changes in the context of COVID-19 from the perspective of federalism? So what you can see is that there are these certain core values in the Constitution: representative democracy, republicanism, federalism, liberty, equality, fraternity, justice, and so on. And to answer the question of what it is for a constitution to be transformative, we have to ask ourselves, what do these words mean? What values do they signify? And how do they apply to a real life situation? Now, to really, I think, focus the point, I want to begin substantively by making one observation. The word for constitution in Hindi, as you know, is... Sorry? Okay, there was an interruption. The word for constitution in Hindi, as you know, is Samvidhan. The root word vidhan and its cognate word vidhi refer, among other things, to a way or a path that you must take if you want to accomplish something. So the constitution as vidhan or vidhi tells us that no matter how noble or desirable the goal is, the purpose is, there is a way that we must follow to get there. And along the way, you have these signposts of values or principles, individual rights, dignity, equality, diversity, the federal structure, and so on. And I think that what it means to be a constitutional republic is that we don't view the destination as being separate from the path that we take to get there. And that brings us back to the debates we've been having over the last year or so about whether the process of altering Article 370 at a time at which the state assembly did not exist was justifiable. Could that be accompanied by restrictions upon communication? And so, to understand if that's right or wrong, it's really important to understand what the constitution as vidhi means, what the processes are, and what the values are that are non-negotiable, no matter what the goal is. And it's here that the idea of the transformative constitution becomes important, because words like liberty, equality, freedom of speech, federalism, and so on, these words did not drop from the heaven one day. Each of these words that we find in the Constitution has a certain history to it. This is a history of struggle, a struggle against injustice, a struggle to achieve a certain kind of freedom. And it's only in understanding the nature of that struggle that we can understand what these words mean and why they matter. So, what is this history that I'm talking about? Now, there's one school of thought that denies to the Constitution any transformative character. This school of thought holds that the Constitution is basically an instrument of continuity. It views the moment of constitutional framing as simply a transfer of power. This school of thought tells us that the Constituent Assembly, after all, was established under colonial British law. It tells us that 75% of the Constitution was lifted from the colonial 1935 Government of India Act. Most importantly, it tells us that many of the most repressive provisions from the colonial times, preventive detention, emergency powers, ironically, two of the precise provisions that are at stake in controversies over the last year or so, and many more ordinance-making powers, governors, also controversial, as you all know, in recent times. These provisions were carried over lock, stock, and barrel into the new constitution. Now, in the Constituent Assembly, there were those who rose to oppose this. People like Somnath Lahiri, K.M. Munshi, from both the left wing and the right wing. There are those who oppose this strongly. Thakur Das Bhargav. They warned that what the new constitution was doing was simply replicating the old colonial structure. But they were told by the majority in the assembly that that was then and this is now, and an elected government, a government of the people, for the people, by the people, would never misuse the legal framework. And on that logic, these provisions were retained. And so, on that basis, we are told that above all, the constitution was an instrument that just continued the old regime. And of course, this is not any mere academic dispute. If the constitution is simply a continuity of a previous regime, then detentions cannot be challenged. The use of central executive power to accomplish goals cannot be challenged, and so on. So it really depends on how we understand what the constitution was trying to do. If we are to judge or to examine many things happening right now, specifically with respect to the extent and limitations of executive power. Now, my submission is that what I have just detailed, these arguments, they present a very narrow way of understanding constitutions and constitutionalism. In my submission, we unduly restrict our vision of the Constitution if we limit ourselves merely to the text of the constitutional document itself, to the debates in the assembly that led to its framing, to simply the political instruments that preceded it, such as the Karachi Resolution of 1930 and similar other documents. My submission is that there is a broader and a deeper history to the words that finally found their way into the Constitution, the signposts I referred to earlier. And that's a history of struggle, because over many years, Indians responded to injustice, political, economic, and social injustice by articulating an entire vocabulary of rights, of freedom, of equality, and of human dignity. The great civil rights lawyer K.G. Kannabiran, in his wonderful book called The Wages of Impunity, puts the point perfectly when he says, and I quote, he says, "A constitution framed after a liberation struggle or a struggle for independence is like poetry, that is, emotion recollected in tranquility. There cannot be and there should not be two social histories, one for political theorizing and another for legal theorizing. The people who met in the Constituent Assembly were not mere technicians who had gathered there to prepare a handbook for running the government. They had participated in the struggles, and short of holding elections, every effort had been made to give their gathering a representative character. That's the end of the quote. Kanabiran points out, therefore, that there is a social history that underlies the Constitution, a history that goes beyond the nationalist movement and the Indian National Congress that dominated that nationalist movement. It's a history you find in the most unexpected of places. For example, you find it in Bankim Chandra Chattopadhyay's Samya, a text from the 1870s that talks about structural and institutional inequality along the lines of gender, caste, and economic status. Far, far before, a century before that very concept became prevalent in Western legal academia in the 1970s, 100 years later. You find it in how Dr. Ambedkar, after whom this university is named, articulated the idea of a right to public spaces during the Mahad Satyagraha, when it was about taking water from the common wells and the temple entry movements. You find it in, for example, Motilal Nehru's speech about executive overreach as far back as 1921. And it feels like he's speaking to the present when he says that the executive cannot engender a sweeping crackdown on civil liberties just for the crimes that might have been committed by a few people. The bulk of the people are innocent of wrongdoing. You can't restrict everyone's rights because of a few people who engage in criminal activities. So you have all these ideas being debated, talked, discussed. And once you expand your gaze to this broader constitutional canon, you find, I believe, that the Constitution was meant to be transformative in two ways. First, it was a politically transformative Constitution. That is to say, it marked a transformation from the colonial regime that viewed the Indian people as subjects to be governed, administered, and when need be, controlled, to a republican democracy that views people as citizens. So from subjects to citizens. Citizens who are entitled to demand accountability from the government. Citizens who have rights against the government, rights to free speech, association, movement, and so on. In South Africa, a country that endured a similar transition from authoritarian rule to republican democracy, this shift is summed up beautifully. They call it a shift from a culture of authority, where authority was answerable to nobody for what it did, to a culture of justification, where every state action that impacts citizens has to be justified to them. And they, in turn, have the right to disagree, to protest, and to challenge it in all the forums available to them. And that's an idea that really comes to the fore when you think of internet shutdowns, communication lockdowns, and so on, because effectively that cuts off the channels through which people can object to or even engage with the decisions that have had a massive impact upon their entire structure of life. So this shift from a culture of authority, which is a top-down relationship where the state imposes its will upon citizens, to a culture of justification, which goes beyond elections. This is not just about elections, but where decisions taken by the state must be justified with reasons. That was the politically transformative character of the Constitution, and that was summed up in the idea of the rights to free speech, association, personal liberty, and so on. But the Constitution, I believe, was also transformative in a deeper sense. It sought to transform not only the relationship between the individual and the state, but also to transform society itself. And this is because, unlike their counterparts in the West, who viewed the state as a monolith, as this one single source of power that needed to be controlled, the framers of the Indian Constitution understood that apart from the state, social institutions, social structures can also impact freedom, equality, and dignity. So, like I said in the beginning, it wasn't the case that if you constrained the state, the residue that would be left over was human freedom. This was the dominant way of thinking in constitutionalism, as Ambedkar did point out in 1946 in that brief document called Notes on Fundamental Rights. But also, as he went on to point out, a way of thinking that was incomplete and insufficient. It was essential to pay attention to the way in which institutions such as caste, gender, and so on created hierarchies, created unequal power relations, and then to question, to undermine, interrogate them. So this was a project of democratization that went beyond just the public sphere and the domain of government. It was democratization that addressed what we think of as the private domain. So a democratization that sought to apply the framework of constitutional rights to private relations, private spaces, private institutions. And this was what was contained in what we define as the Constitution's horizontal rights provisions. That is, rights applicable between private parties and not the state. So a vertical right is a right that applies against the state. Right to free speech means the state can't censor you. A right to personal liberty means the state can't imprison you without due process of law. But a horizontal right is a right that applies between two private people and the state is not involved at all. And constitutions all over the world have been very hesitant to codify horizontal rights because of this whole idea that Ambedkar criticized, that they thought that the state is the only oppressive force. You control the state through vertical rights, you're done. That is all that a constitution needs to do. But the Indian Constitution, right from the beginning, disagreed with that view and contained specific horizontal rights. So, for example, Article 17 prohibits untouchability, a social institution, and we all know the long history behind that struggle. And this is, of course, a fitting commemoration of that struggle by naming this university after Dr. Ambedkar. Article 23 prohibits forced labor. So it applies to the relationship between employers and employees, between labor and those who control the means of production. And as I flagged in the beginning, the famous Supreme Court case of PUDR versus Union of India, where it was held that the right against forced labor included right to a minimum wage. And then we have Article 15, Clause 2, that guarantees non-discriminatory access to shops, restaurants, hotels, and so on. If you look at the history of this provision in the debates of the Constituent Assembly, you will find that this was essentially an anti-boycott provision. That is, it was meant to defeat the social boycott, a process through which large sections of society were denied access to some of the basic goods and services that are necessary to sustain a decent life, and indeed were kept segregated physically, economically, socially, and culturally in order to keep them subordinated. And so, on the one hand, you would all have heard about the famous golden triangle of the Constitution. 14, 19, 21, Supreme Court has said multiple times: equality, freedom, life, and personal liberty. That is the golden triangle of vertical rights between state and the individual. And I would submit that 15 Clause 2, 17, and 23 is the second golden triangle, because that speaks to the Constitution's deeper, socially transformative character. So that is broadly what is the Constitution's transformative character that I'm talking about. Now, in the last 15 or so minutes left to me, I want to focus on one story spanning 100 years that I think really exemplifies this idea of the transformative constitution. It's one of the most fascinating and moving stories I have come across, and it's a story I think that has just about everything you want in a story. It's a story that begins in the late 19th century, in the 1880s. Rukhma Bai was a young woman who, at the age of 11, was married to a significantly older man called Dadaji. Rukhma Bai's parents were dead, and she was brought up by her uncle, who educated her. She did not live with Dadaji, and he never sought her out either. However, when Rukhma Bai turned 18 and stood to come into a substantial inheritance left to her by her parents, Dadaji suddenly woke up and realized that he was married. He suddenly remembered after all these years that he had a wife. He asked Rukhma Bai to come and live with him. Rukhma Bai naturally refused. At this, Dadaji went to court. He invoked the provision of the Restitution of Conjugal Rights that I'm sure you all know of. Ironically, a colonial implant that had no origins whatsoever in Indian family law. It was literally brought from the Matrimonial Causes Act of 1865 in England and just transplanted into Indian law with no basis in our own history of family law. Now, the Restitution of Conjugal Rights provisions, I'll just go over it briefly, requires that if one spouse has unreasonably withdrawn themselves from the company of the other spouse, then the court must pass a decree requiring the former to go back to the latter, hence restitution of conjugal rights. Under this provision, the courts would determine whether the withdrawal was unreasonable or not. Now, Rukhma Bai defended herself, and much to everyone's shock, she won the case in the first instance. The judge of the Bombay High Court hearing the case, an English judge, Justice Spinney, held that he would not order this woman to go to a house she had been married into at a time at which she had been so young and effectively unable to provide any meaningful consent. And so you can see here in a very incipient form the first idea of why consent matters, why the individual matters, why rights matter beyond the state, because this had nothing to do with the state. This was a dispute between Rukhma Bai and Dadaji. Now, Justice Spinney's judgment led to a huge backlash. It was argued that the English, with their Western notions of rights, were unduly interfering with the sacred domain of the family and of community values, which is ironic because, as I just said, restitution of conjugal rights was literally imported itself from the Matrimonial Causes Act in England. This argument is as old as the hills, that institutions like the family, the home, the community are immune from civil law, from constitutional rights, from ideas of freedom and equality, because they belong to that private domain where the state's writ may not run. But perhaps what is most fascinating is that this backlash against the judgment of the Bombay High Court did not go uncontested. Indeed, the response was led by Rukhma Bai herself. In two anonymous letters to the Times of India, it used to exist even back then in the 1880s, titled Letters from a Hindu Lady, Rukhma Bai set out an eloquent and impeccable argument for how marriage imposes very different obstacles and barriers upon women as opposed to men. Rukhma Bai, of course, did not possess the conceptual vocabulary that was developed many years later. But nonetheless, what we see in her letters is a clear understanding and a clear articulation of the relationship between the principles of equality and how they must operate even within the marriage and not just when you're thinking of the state. And Rukhma Bai was supported by many prominent social reformers of her day, men and women both, like Behram, Malabari, Pandita Ramabai, and so on, all of whom together articulated a language of rights, of freedom, and of inequality that applied within and against these institutions and social structures like marriage and the family life. Now, you won't find these arguments in political philosophy books or textbooks, which is the model of scholarship that we have become far too accustomed to. But you will find them in memoirs, in letters, in records of public debate in newspapers and so on, because it was not in books, but it was in these kinds of public forums that this whole transformative canon, this idea of rights, equality, freedom, and so on, really sprung to life. Unfortunately, it wasn't enough because the appeals bench of the Bombay High Court reversed Justice Binny's decision and held in favor of Dadaji. Rukmabai appealed to the Privy Council, which is obviously in England, and to then Queen Victoria. So the Privy Council at the time was the highest court that would hear the final appeal from any court in the British colonies. In some cases, it still does that. The Caribbean nations and so on. So Rukmabai appealed to the Privy Council, and this is going to be a final battle in the Privy Council. But at this point, Dadaji probably realized that it wasn't worth the effort, so he entered into a settlement with Rukmabai and dropped the case against her. And Rukmabai went on to become one of the first trained female doctors of India. So her story had a happy ending, even though the case did not. But now, fast forward 100 years, from the 1880s to the 1980s. This story brings us right back to very recent times. The High Court of Andhra Pradesh in Hyderabad, back then, the High Court of Andhra Pradesh in Hyderabad. The case involved another young woman called Sarita, who at the age of 16 was married to one Venkat Subbiah, an older person. They did not live together. Over the next 5 years, Sarita became a famous and popular actress. And much like Dadaji, Venkat Subbiah suddenly realized and woke up and realized he'd been married for all these years. Like Dadaji, a century before him, he asked Sarita to come back and live with him. Like Rukmabai, Sarita refused. And then, like Dadaji did, Venkat Subbiah filed a suit for restitution of conjugal rights. And like Rukmabai, Sarita defended herself. But here is where their paths diverged, because Sarita had something that Rukmabai did not, which was the Indian Constitution. Sarita argued for the first time in our constitutional history that the provision allowing for the restitution of conjugal rights was unconstitutional. She argued that it infringed upon her right to privacy, that is, her right to take intimate and private decisions on her own without coercion either by the state or by any other private party or institution. And Justice Chaudhary of the Andhra Pradesh High Court agreed with her and struck down the provision as unconstitutional. Now, it's worthwhile, I think, to take a pause here and step back for a moment. If we think about how the concept of privacy evolved as a legal concept, starting in the United States at the end of the 19th century, we find that it took two forms. The first was the privacy of spaces. Contained in the old chestnut, "A man's home is his castle," the privacy of spaces held that there was something sacred, something morally salient about spaces like the home. The home was the threshold beyond which the state could not come. And what happened beyond the threshold, what happened inside the home, was nobody's business, not the state's business at least. The second form was the privacy of institutions or relationships. According to this form, there was something morally important about relationships like the marriage, the family, and so on, that we protected from state interference. For example, in the US in the 1960s, there was a law that prohibited married couples from using contraceptives. The US Supreme Court struck down this law on the basis that what happened within the marital relationship was not the state's concern. Another example is that of the Irish Constitution, a document from which our own framers borrowed heavily. The Irish Constitution has an article that sets out the family as a fundamental unit of constitutional concern. So these were two dominant ideas of the right to privacy, spaces and institutions. But Sarita was articulating a very different idea of privacy, an idea that came into direct conflict with the privacy of spaces and the privacy of relationships. She was seeking privacy for herself as an individual in and against these spaces, the home and the relationship of marriage. She was making the argument that Rukmabai had made a century ago, but now with the constitution on her side. And it was an argument that Justice Chaudhary found compelling, because what he held was that an individual did not lose their right to privacy on entering into the marital union. And the restitution of conjugal rights effectively transferred some of the most fundamental and intimate decisions and choices away from the individual. It was therefore unconstitutional. Sarita and Justice Chaudhary's arguments will, of course, be familiar. For many decades, lawyers, judges, scholars have argued that privacy, as traditionally understood, being about spaces and institutions, is blind to the hierarchies, the inequalities, and the relations of power that exist within what we understand as private spaces, and thereby ends up perpetuating and entrenching those inequalities in a manner that severely curtails freedom and equality. And for us in India, those arguments had their origins in Rukmabai's battle in the 1880s and came to fruition a century, freedom struggle and a constitution later. And that's what I meant when I said that you have to look at this whole history of social movements before the constitution to understand its transformative character and the manner in which something like the right to privacy is a transformative right, as recently held by the 9-judge bench. Now, the story did not end here either. The same year, Delhi High Court was also considering the same question, that is the constitutionality of the restitution of conjugal rights provision. The Delhi High Court came to the opposite conclusion. It decided to uphold the provision. What's most interesting, however, as students of constitutional law, is the language that the High Court used. It observed that that cold constitutional law could not be allowed to enter the warmth of the home, and that doing so would be like bringing a bull into a china shop. The issue of temperature differences aside, this is exactly the argument made 100 years before in the backlash to Justice Pinney's judgment in Rukmabai's case. That the space of the home and of the family has its own governing principles, its warmth fundamentally at odds with, say, the cold objectivity or detachment of law and of constitutional rights. A couple of years later, the Supreme Court was asked to resolve the conflict, and the Supreme Court also upheld the provision. It upheld Delhi High Court's judgment and reversed Andhra Pradesh High Court's judgment. But even that story is not yet over, because now, as we all know, in 2017, a 9-judge bench of the Supreme Court was asked to rule upon whether privacy was a fundamental right under the Indian Constitution. And the history that I've talked about for the last 20 minutes gives you a sense of the many different answers, the many rich and complex answers that there are to that question. And in fact, in answering the question in the affirmative, the court also went into the question of what precisely was meant by the right to privacy, and came down strongly on its transformative character, being an individual right and not a right accorded to spaces or institutions. Indeed, writing for himself and 3 other judges, Justice Chandrachud devoted 2 pages to discussing the critique of privacy that's often come from women scholars, and held that any conception of privacy would have to take into account and address this critique. Is a resurrection of Justice Chaudhary's transformative vision on the cards. We don't yet know, and only the future will tell. But in conclusion, that is what the debate is. The conflicting judgments of the Andhra Pradesh and Delhi High Courts represent two competing visions. One is transformative and one is a continuity vision. One is emancipatory and one not so much. One questions the kinds of power relations that exist even beyond the state and into the private domain, and one is aimed at preserving those power relations. Of course, it's not for me to say one is right or wrong. That's the question all of us have to collectively deliberate, discuss, and come to a conclusion about. And in many different ways, these are the questions that we face today. The Constitution is the terrain upon which these questions are debated. In the courtroom, yes, but as we have seen, far beyond the courtroom, in public debate, in our daily lives, in the institutions we participate in, and in the relationships we have with others. And I suggest that the stories of Rukmabai and Sarita point us to the direction in which we may answer these questions, and indeed the direction with its signposts in which the Constitution of India imagines answering them. So I see I've taken exactly 45 minutes. So on that note, I will close. I hope this was interesting, and I look forward to discussions and responding to the questions that you may have.
Okay, thank you very much, Gautam, for your talk, which was indeed a very compulsive listening for all of us. And I'm sure everybody has enjoyed signing into this webinar and listening to your talk for the past 45 minutes. If you permit, can we throw the platform open for questions now?
Of course, yes, please.
Yeah, okay. I'd just like to find out, does anyone from the Zoom meeting room want to present a question directly here right now? We could allow that if you're willing to do that, or I can take questions which have already come to me. Okay, maybe till anyone volunteers to do that, I would pose questions which I have already got. The first question that we wish to ask you is that so long as, we talk about judicial initiative in the entire transformatory project, how far do you think that this judicial initiative is effective in terms of really bringing about a change in the lived experiences of people, particularly those who are living on the margins? Because if it doesn't really bring about that change in their lives, then maybe transformative constitutionalism becomes something that is, only to be textually glorified as a jargon. So what's your response?
Yeah, I think that's an excellent question and a very important one. And it's a difficult one to answer, but I'll make an attempt. So I think it's completely correct that transformative constitutionalism that is imposed from on high without a sense of lived experiences is not going to work, because it will not make sense to those whom it is meant to emancipate and to give freedom to. So I think that is, to me, very clear. I think that the relationship between transformative constitutionalism and the people is basically a symbiotic one. And so I would take the example of the Section 377 case, that Navtej Johor's case that happened recently. If you look at the history behind that case, it's a very old history. The first challenge to 377 was actually made as far back as 1995. That's 25 years ago. Then there was this next challenge in 2003, Nas Foundation's case, that first the High Court said we are not going to hear. Then the Supreme Court said, no, you need to hear this case, and it sent it back. And then in 2009, the High Court read down Section 377. 2013, Supreme Court reversed that. And then again in 2018, Supreme Court changed its mind. But if you look at what was happening around that entire time, you find that there was a very powerful movement that was led by the LGBTQ plus community that engaged in the public sphere, that engaged with law and engaged outside the court to change public opinion, to transform perceptions. And so when you actually came to 2018, in fact, the government of India did not even defend Section 377. They said we will leave it to the wisdom of the court. So there wasn't even opposition from the government. That's how far the movement had come. And so I think what this teaches us is that to the extent that we want to achieve transformative constitutionalism through the courts, simply litigating and just going to court and hoping that a right will be declared is not enough. There needs to be a movement, a social movement, that first frames the debate outside the court, that is able to engage outside the court, and it's that movement that should then decide if they think the court is the right way to go about it. And I think that when you have a combination of all these factors, then you have a situation where the court can play an important role in furthering a transformative vision. Sometimes it may not, the court may not be involved. So I think if you look at the right to information movement, from the time the movement began to the time at which the RTI Act became law, it was a very public social movement in Rajasthan led by the Mazdoor and Kisan Shakti Sangathan. And they basically persuaded the parliament to pass an RTI law. Same with the Forest Rights Act. So I think that sometimes when all things come together, the court is a good vehicle to advance the transformative vision of the Constitution. And sometimes it has to happen elsewhere. And that's a debate for each specific situation.
Okay. Thank you very much for that response. There's another question that comes from K.R. Datta, where she draws attention to Article 15 of the Constitution. Basically, Article 15 is one provision that has a huge potential for social transformation. And but then she says that Article 15 is not being properly followed. So what is your opinion of this, number one? And she says, how can we change the view of the society, keeping Article 15 in mind? That's her question.
15 has many subclauses, so I'm wondering what specifically she means. I mean, I'm going to assume that. Unless there's clarification, I assume that it's about 15.1. That's the Non-Discrimination Clause.
Yeah, I don't really have any specification on the question coming from her, but if you could just take it generally, otherwise maybe
sure. No, I think yeah. So what I would say is that we need to go into, so let's take Article 15 Clause 1. The state shall not discriminate on grounds only of the five grounds: sex, race, caste, religion, and place of birth, or any of them. So this is a very, very basic and standard non-discrimination clause, which you find in countries all over the world. The key question is, what does this mean, and why these 5 grounds have been chosen? And that's where we have to ask ourselves that question. And if you go back into the debates and you look at the origins of this clause, what connects these 5 grounds, that is sex, race, caste, place of birth, and religion, is that one is that they're very hard to change. Like a person cannot really change their place of birth. A person can change religion, but it's not easy. Like religion is something that's really fundamental to you. So changing it is not something you do, just like that. And obviously, changing your sex is like, I mean, again, it's medically possible, but it's obviously doesn't happen very often. So these are personal attributes, personal characteristics, and that either cannot be altered or can only be altered at some social cost. And the second is that historically, these grounds have been the sites of a certain kind of oppression or persecution of people. If you look at history across the world, it's always religion, sex, caste, race, and so on. And so the idea underlying this article was that you have these personal characteristics of people that have historically been used to single them out and to oppress them, and that has to stop now. That needs to go, and to, I think, really give a power to this clause, that we have to understand that in that way, and also understand that there are other grounds that the framers were not aware of because they didn't exist back then as something, as something that it's in your mind, but have the same characteristics. So, for example, disability. Disability is something that again is something. It's a condition which is very hard to alter, and it's historically been used to deprive people of equal access. So, disability, in some cases, age, socioeconomic class, and so on. So, I think that to really give power to Article 15, we need to understand this basis and then use that to say, okay, you have these other grounds that may not directly come under Article 15, but require a higher scrutiny under, say, Article 14, or require more rigorous judicial scrutiny than just any other classification. So I would say that that's how we should understand this clause. And it's a very German constitutional court judge called Susanne Bayer, very famous judge. She says that equality means anti-hierarchy. So wherever you find an hierarchy being created, that's where an equality clause has to come in.
Okay. There's another question that's coming from Rahul Bajaj. His question is, do you have any ideas for how a clash of rights can be resolved if the Constitution is recognized to inform private relations?
Yeah, that's a great question. There are 2 or 3 answers to that. One is an answer the Supreme Court recently provided in its RTI judgment, where it said that that you have to do a proportionality analysis. So basically, you ask yourself, you have these 2 rights. These 2 rights clash. So what is the proportionate solution? And what the Supreme Court said was that neither should be effaced. So if you give an interpretation that effaces one right or another, that you can't do, and you have to interpret it in a way that both are restricted to the least possible degree. So the clash must be one that restricts both to the least possible degree, and of course that's something you apply on a case-to-case basis. That was in the context of a clash between 19 and 21, and there are arguments in scholarship that you should extend that to a purely private context. I don't necessarily agree, because I think proportionality may not best fit within a private context. What I would say is that what you should look at is in a private right, in a clash between of private rights. That where does the power lie? So, for example, in the US, you had this big controversy for many years, where you had white people who had houses in the best parts of the city, and they would sign these contracts saying that we will not sell our property to any person if they are either black or Jewish. So these were called racially restrictive covenants. So the idea was you ensure that the best parts of the city are kept in the hands of white people, and the others live elsewhere in ghettos and in bad conditions. And so now that's a private contract, right? It's a purely private relationship. But the question there is that people who have more power in society by virtue of their race, their gender, whatever it is, if they are using that power to block other people's access to basic rights and to oppress them, then the rights of those people should be invoked against the more powerful. So I think that is how you should adjudicate a clash of rights between 2 private parties. You have to ask if the more powerful party is misusing their position of power to violate the rights of the less powerful party. And that was the underlying idea of the Supreme Court in PUDR's case, saying that there's a right to a minimum wage, because the Supreme Court said that, look, what happens is that private employers take advantage of the widespread demand for employment and then drive down the wages. So you have to stop that. So I think that would be the framework that within which you would you do that. Yeah.
There's a second question again coming from Rahul Bajaj, where he wants to ask you that has the Supreme Court, in your view, outlined a rigorous and thoughtful vision of the Constitution's transformative feature?
In some judgments, yes. In the Nagpur judgment, it was done well. In the privacy judgment, it was done well. In the adultery judgment, it was done well. If you read the entity of Delhi versus Union of India judgment on the Delhi Union conflict, there was a fairly good articulation of representative democracy as a feature of the constitution and why that's important. A few high court judgments have done well on pregnancy rights in the Delhi High Court and so on. But I think that we don't yet have a coherent way of thought. We have some judgments that explain what the concept is, but it's not. So unlike say Maneka Gandhi, which introduced due process into the constitution and that became part of. I don't think we are quite there yet. It's good to, for example, compare it with South African constitutionalism, which actually the phrase transformative constitutionalism comes from there. That's the South Africa was where the phrase was first came, although the idea is of course much older. And so there they have I think a more rigorous program of what that means. So I think we have a way to go yet, but there are the base of understanding and discussing that. And it depends upon all of us how we collectively go together and talk about this and what we think it means in practice.
Just to add to that, Gautam, what according to you were the missed opportunities, if I could call it that way, that where the court could have taken a very transformative stand and it just failed to do that?
Yeah, that's a wonderful question. I think one question I would say that if you look at the 1960s. There were a few cases I think which we could have gone one way but didn't. So I think, for example, the Kathi Kalu Ogad case on self-incrimination. Now, if you look at the history of our colonial times, there's this whole idea of the fact that once a person is accused of a crime, they effectively lose safeguards because the whole philosophy is you must solve the crime, come what may. Whereas once the constitution comes into being, you have a sense that solving the crimes is important, but you can't torture people. Just to take an extreme example, and so there's still some barriers you put on what the state can do. And I think that in a case like Kathi Kalu Ogad, when it came to interpreting self-incrimination as a fundamental right, the court could have engaged with why is it that we want to protect an accused person? What are the values we are trying to protect here? Which it didn't do. So I think that's one example I would say that was a missed opportunity. And I think maybe the very famous case of Narsoppa Mali, where the Supreme Court said that personal laws by definition are outside the scope of the Constitution. Yes, I think that set us back in many ways, and it has ensured that, for example, something like the Uniform Civil Code it becomes harder because then you have this whole idea that you can't impinge on non-codified personal laws. So things like that, yeah.
Okay. There's another question that is drawing attention to Justice Chandrachud's judgment in Sabrimala, which is cited as a great example of the transformative approach, where he extends the application of Article 17 to the women who were excluded from entry. Now, the question is that practically, how effective is this extension? Because if we look at the language of 17, it says that this practice is abolished and its practice in any form would be, punishable in accordance with the law. But the law that we have in place is not one that is able to cover women. So what meaning does it remain in the face of this?
Yeah, that's a very, very good question. I think that's so there are two things, right? One is that so you need to have a law that specifically defines the offense and sets out what the punishment is. So that is one thing that we have for caste-based untouchability, which is there. But that's not the only way a constitutional article can act, right? So if you see the way that Justice Chandrachud applies it in the Sabrimala case, and of course this is not good law because it's only his concurring opinion and none of the other four deal with the issue. So it's not the position of law, but it's an example of how it might work. Is that if you have some other law or some other rule, in this case the law and the rule there that prohibited the entry of women into the temple, and you can interpret it in two ways. you interpret it in a way that advances the goal of Article 17, in this case as understood to protect women as well. So framing a separate law with a criminal offense is not the only way of implementing Article 17. It can also work in different ways. When you're interpreting existing laws, you interpret them in a way that conforms to Article 17's transformative understanding. You could even have a law that directly violates it and you strike it down. So there are other ways a court can engage with Article 17, even in the absence of a specific criminal law that exists on the statute books. And I think I actually feel like it's more powerful that way, because I think criminal law has its limits in doing what social change.
Yeah, correct. There's one question. I don't know whether you'd really choose to take that, but I'm putting it to you anyway, leaving the discretion to you. The question says that you've said that the way Article 370 was scrapped is a point to be decided. Keeping the constitutional provisions in consideration and earlier judgments, what is your opinion on that? And was that not a constitutional fraud on the people of Jammu and Kashmir?
So I mean, since I'm formally involved with the case, I can't answer that question here. Our petition is online and can be viewed. What I will just say is it's a good question, and I do sincerely believe that it's a case that is a very close case, in that there are good arguments on both sides given the specific legal history at play.
Okay. There's another question here. Isn't the idea of social transformation and personal freedom contradictory?
No, I think it's complementary. So this social transformation exists for the furtherance of individual freedom, and I think what I would say is that because we all live in society, individual freedom has no meaning without a social context. And so I think the idea is that you engage in social transformation to make so that people can be freer. I think a good example of this in recent times was the original triple talaq judgment. So I'm not on the criminalization of triple talaq. There's different debate over there. But when you look at the Supreme Court judgment striking it down and saying it has no legal force, then that's, I think, an example of an attempt of where changing a social practice is used to further freedom. If you go back in history, the abolition of bigamy in the 1950s, in multiple religions and so on. So things like that, I think, are examples where social transformation is brought about to ensure that individuals have more freedom. And I think the underlying idea is that there are some members of society whose freedom is constrained by social structures, whether it is caste or the family or so on. And the purpose of transformation there is to, increase the freedom that they have to enjoy.
Okay. There's another question put up by Dr. Adhara Deshpande, who wants to know that, do you feel that the media is directing public opinion with regard to the Constitution?
I think the media is a very powerful institution in society, and what the media does have an impact on how people understand the Constitution. So I think, yeah, definitely, it has that is true. What the exact nature is, I think that's open to debate, but there's definitely a strong influence it has.
Okay. Another question says that with regard to the Setu app and other government apps where data privacy may not be assured or protected in that case, will it not restrict or breach the right to privacy? And the same requires proactive statute for protection of privacy and data privacy in this.
Yeah, it's important to have a law that sets out the contours of data protection, and any such law must be proportionate. So there are 4 steps in the proportionality test. There must be a law, of course. Secondly, there must be a rational connection between collection of data and the goal of the state, in this case, preventing COVID-19. Thirdly, there must be the least restrictive measure taken. So if there are other measures that involve less intrusion into the collection of data, but are equally efficacious in fighting COVID-19, then a more intrusive measure should not be undertaken, and that's a matter of debate. And fourthly, that there must be a balance between the goal and extent of the restriction. And any data protection law must have these 4 steps as a compulsory thing the state must go through.
Okay. Thank you for that response. Another question that we have is from Chetan Dhore. He says, as we understand, transformation is diametrically opposed to something which is static or stagnant. To prevent constitution from becoming a stale testament, do you think frequent amendments would be necessary? And if so, how do you see compliance to the basic structure doctrine in these changing times?
Yeah, that's a very good question. It's a debate that's as old as constitutions themselves. And Thomas Jefferson thought that every 20 years you should have a new constitution because every generation, should have a chance to frame their own constitution. So I think that dynamism is really important. And I think the fact that we've had 101, I think at last count, I may be off by a couple amendments to the constitution is testament to its dynamism, and some may say it's too dynamic, it's too easy to amend. I think that's a debate worth having. So I don't think the basic structure presents a problem. It's evident in the fact that in last 47 years since the doctrine came into being, it's actually been used to strike down an amendment, I think it's 6 times. And there have been like multiple amendments through that time. And I think that the point of the basic structure doctrine is it's a very restrained doctrine, in the sense that what it says is that if you can amend the constitution, but it says to be recognizable as that constitution. And I'll give you an example. In my view, if you were to alter the structure of the government from a parliamentary to a presidential system, that is not a basic structure violation, because you're still democratic, right? Presidentialism and parliamentarianism are 2 different ways of doing democracy. And so that amendment is far reaching. It'll alter kind of like many provisions. I think it's completely consistent with the basic structure. But if you abolish elections, abolish suffrage under Article 326 and make it a monarchy, then that is not the same constitution anymore, because that is not a democracy, and democracy is a basic feature. So I think that if you, and just to also clarify, I don't agree with the way the Supreme Court has used doctrine in cases like the NJSC. I think it's overstepped and used it in little too much of a intrusive fashion. But I think as conceptualized, basic structure is a very, very light touch kind of a doctrine that would only come into play if you're doing something as far-reaching as turning a democracy into a monarchy. Short of that, it's not going to be a constraint on Parliament's amending powers. And then I agree about the fact that it needs to be dynamic, and an amendment should be reasonably easy. Whether they're too easy in India, I think that needs some more debate and thought.
Okay. You spoke, Gautam, about the right to privacy, and you mentioned the Rukma Bai case and provisions like restitution of conjugal rights. But now with the right to privacy becoming a fundamental right as pronounced by the Supreme Court, how do we, in the light of that, how do we reimagine the regime of reproductive rights of women? Does it not pose great kind of challenges to this balancing?
Yeah, I mean, that's a really complex question. I think it's almost impossible to answer off the cuff. I think that the privacy judgment is very important to reproductive rights. It gives them a great fillip and places them on firm constitutional foundation. And I think it would have an impact on how we interpret laws such as the Medical Termination of Pregnancy Act, the MTPA, and similar laws, because those laws, despite permitting things like abortion, nonetheless place a range of restrictions on that right. 20-week period, which is sometimes extended, and medical permission, and so on. So I think that there may be scope to ask if that law is still consistent with the idea of privacy as articulated in the Puddaswamy judgment. What specific form it takes, I don't yet know. I think that's something we'll only know with time. But I think that it definitely, in its focus on the individual right to privacy, it does really place reproductive rights on a firm foundation and offers pathways going forward to engaging with laws like the MTPA and so on.
Okay, there's one question here that does transformative nature resonate with the idea of putting morality into black and white letters of law to make the much required morality enforceable?
That's a good question, and I think that I think the answer is that yes and no, in the sense that you can't legislate morality. I mean, that's something that has to come from bottoms up. It can't be imposed from top down. But to the extent that I think that the role it plays is that, again, if you are interpreting a law and you have two possible interpretations, the one that furthers constitutional morality, and that by that I mean the transformative values of the Constitution, is to be preferred over the one that does not. And I'll take two examples of this. One is the NCT of Delhi versus Union of India case, which turned upon the interpretation of the proviso to Article 239 AA, Clause 4. Question was that to what extent is the Lieutenant Governor of Delhi, who is not elected by Delhi's people but is a nominee of the central government, to what extent is he bound by the aid and advice of Delhi's Council of Ministers, which is the elected Delhi government? And there was a controversy over that because the article was very ambiguous and very vague. The Supreme Court said that if you look at the history of our constitution and our democracy, it's been a move towards more representation, right? So we've gone from a place where in the 1919, where you had minimal representation, 1935 Government of India Act that had more of it, independence, and so on. So you can see that there's been a shift towards ensuring that the government is responsive to the people through representativeness. And so that is a fundamental transformative value in the Constitution. And so when you have two possible interpretations, then you select the one that would advance the value of representative government. That's what they did in that case. And of course, if it was effective or not, different debate. And similarly in the Navtej Johar case, where again, the idea was that that discrimination on the basis of sexual orientation, that is a personal characteristic beyond people's control or is a fundamental intimate choice of people, that can't be a basis to discriminate against them. So that's a core moral idea, that you don't oppress people on the basis of these very personal characteristics. So that again, the role of morality there in reading down the law was very obvious. To that extent, I think that constitutional morality plays a role in what the courts do and how laws are interpreted, but not beyond that. Beyond that, you can't impose it from top down, I think.
Okay. Thank you very much for that. One question is about the separation of powers challenge when it comes to judicial initiative in transformative constitutionalism, given the fact that this comes from the non-democratic judiciary. So that's the basic question, that how do we meet the separation of powers challenge there?
Yeah, that's a really, really important question. And I think that the first thing is to acknowledge that while the Constitution is transformative, the Constitution imagines that different vehicles of the state will act as vehicles of transformation for different contexts. So the entire burden of transformation is not upon the court; it's upon the legislature and the executive as well, and they have their respective spheres of action. I think the Supreme Court has to be aware of that at all times. I think the really key point here is, how do you understand democracy? And what I think is that when you look at transformative constitutionalism in the sense of horizontal power relations between private parties, what you're basically saying is that look, if you have oppression and repression in the private sphere, then those people who are at the receiving end of that are in no position to participate in the democratic processes of the nation. So if you have a community which is being socially boycotted and is unable to, walk on the roads or, draw water from the wells, what kind of democratic participation will they be in a position to engage in, right? So what should guide the court is to in these kind of controversial cases, which is where you have more than one possible interpretation and allegations of overreach and so on, is judicial intervention going to deepen democracy in that sense, which means that for those people who are being oppressed by private structures, will this decision or this intervention enable them to move beyond that oppression and adequately then participate in the democratic society. And if that is possible, then the court should intervene. If not, it should stay out and let other bodies deal with it. And of course, is something you decide on a case-to-case basis. But I think the question is very important, because I think the court has to be aware that it's not the only branch that is engaged in carrying out the Constitution's transformative purpose. And separation of powers is really important to keep in mind and adhere to.
Okay, as such, we are at 5:14 p.m. But if you permit, can I take about the last maybe couple of questions?
Happy to.
My inbox is flooded with a number of questions.
Happy to go on.
I can't possibly take all of them, but I'm just trying to pick up a few questions which are, relevant to the theme of today's talk.
Yeah.
There's one question that says that when you say, or when you talk about picking up a right path to do certain things, are you referring to the letter of the Constitution or the spirit of the Constitution?
So I think that the spirit of the Constitution is something that you draw from many things, including its letter, right? So you can't have an interpretation that just ignores what the constitutional text says. So the text is really important, but the text itself is not self-interpreting, right? So what does equality mean? What does equal protection of laws mean? What does it mean to not discriminate? What does liberty mean, right? These are all words that have 300 years of history at least. And so then the question becomes that you have these 5 possible meanings to equality. Which is the constitutionally correct meaning? And that's where spirit of the Constitution, and I wouldn't use that word, but I know the context in which it's being used, so I'll go with it, becomes important, because that tells you which of these multiple textual meanings is the one that our Constitution subscribes to. And that's where you look at the history of the framing, the debates, social movements, and then you kind of understand that when our Indian Constitution uses the word equal protection of laws, it means this, right? And so that's how the letter and the spirit kind of interact with each other.
Okay. There's one question which says that India witnesses a conflict of individual rights and group rights. Do you think that the Constitution should address this in a transformative way on lines of the Western concept, or find a blended way of its own?
That's a really good question. And so my own answer, and this is just my view, is that it's something I call the Anti-Exclusion Principle. So what I mean by that is that in a clash between individual rights and group rights, if the impact of that group decision, which is taken by the leaders of the group, is such that it excludes an individual from being able to access very basic goods and the very basic amenities that allow a dignified life, that is the point at which you curtail the group right for the individual. An excellent case study for me is the Dawoodi Bohra case from 1962, I think. Question in that case was excommunication from Dawoodi Bohra society. And if you look at what happens when you excommunicate a person, basically they are completely out of society. They can't access the common burial grounds. They can't eat from the society's common utensils. They can't access the common spaces. Effectively, they become completely outside the society and lose all social contact with the community, because the chief has said you are hereby expelled. Now, in that case, Justice Sinha's dissenting opinion, if you read it, Chief Justice Sinha, as he then was, he makes this case. He says that, look, the impact of an excommunication is effectively a civil death, right? So that is what the impact is. And so here we will step in and we will stop that, because the group right cannot extend to the point at which it effaces the individual from being able to live any kind of dignified life in our society. And that's what explains Article 15, Clause 2, 17, and so on. So I think that's where you draw. So the group has the right to determine its own rules. 26B specifically says that denominations can do that. That's a very valuable right in society that should be there. To the point at which the individual still is able to live a dignified life. That's the balance you need to draw. That's my view.
Yeah, in fact, there are a lot of questions coming to me where people are wanting you to talk about, Article 25 and transformative constitutionalism. So I think, can you just throw some quick light on that? And I think on that note,
Yeah.
we will end, because I can't possibly be putting all these questions that
No worries. If anyone wants over email, I'll be happy to answer. So 25, yeah. So I'll just say, so I wrote an article on this in Global Constitutionalism, which I'm happy to share, that sets out in detail what I think the interpretation is. So I'll share that with you after this talk. In brief, I think that there are multiple rights that are there in 25 and 26. 25 is the individual right to freedom of conscience and religion. 26B is the group right to manage affairs in a denomination. 25(2)A allows the government to intervene in non-religious activities and so on. So there are these multiple things happening there. So you have like a number of entities. You have the individual, you have the community, you have the state, and you have the court. So you have at least 4 entities who are like kind of playing roles in these articles. I think that in line with the anti-exclusion principle, one thing I think is that the ERP test should go, because it's not the court's job to decide what is essential or not, right? That the community has to decide. If the community thinks that it's essential, it is essential. Like that is not the court's job. And so that the court should stop doing it, stop getting into that question. The court does, however, need to get into the question of where to draw that boundary line between what is religious and what is not, and therefore what falls within 25 and what doesn't. And that, I think, again, should not come on an a priori kind of a basis where the court says, okay, like we are telling you what it is and what isn't. Again, what you look at there is something like the anti-exclusion principle, which is that, okay, is the impact of this going to be on a person's civil rights? Something like marriage, like inheritance, property succession, and so on, right? Things that are impact individual civil rights, right? On those issues, they fall outside 25. And if you look at actually Ambedkar's articulation when he was talking about this, he said that because the conceptions of religion in the country are so vast from birth to death, we have to obviously limit the scope of the individual right to religious freedom. And so we will limit it to what is essentially religious and not to succession, property, and so on. Somewhere in the 50s, essentially religious becomes essential religious, that LY goes and it becomes something totally different. So I think that the answer is that the religious community must decide for itself what is essential to it or not. And its scope extends to religious matters. And where civil rights of an individual are impacted, that's where that right ends of the group, and the Constitution comes into play. I think that that's broadly a way of doing this that respects the community, it respects the individual, and it respects the Constitution as an instrument of regulating that relationship.
Yeah, okay. Well, thank you very much, Gautam. I have so many reasons to thank you. First, for agreeing to come here for this talk. Second, for so patiently addressing so many questions that were put to you. I indeed do apologize because I could not take in all questions. So for those of you who put questions into the chat box, I truly do apologize that we could not pick up all of those questions for constraints of time. But thank you very much for this wonderful deliberation and discussion that we've been able to have on transformative constitutionalism.
Thank you so much for inviting me. It was a great honor for me, a great privilege. The questions are wonderful, and if anyone has further questions, hopefully at a future time we can talk about it in person sometime, maybe in Nagpur, hopefully. Yeah.
Oh, wonderful! That's wonderful. We can think of having that sometime in future. Well, as we come to the end of this webinar now, I call upon my colleague, Dr. Sandhya, to please propose our vote. Thanks. Over to you, Sandhya.
Thank you, Varsha. Honorable dignitaries present over here and all participants of this one-day national webinar, a very good evening to all of you. It is indeed my honor and privilege to put on record words of appreciation and thanking to Mr. Gautam Bhatia for bestowing upon us a bowl of wisdom from his ocean-like expanse of intellectuality. Every word of yours, sir, was as pleasant as those very first drop of rain. Your talk was so enthralling, and we were so lost in your loop of wisdom that the time just flew away. I must say, this webinar was indeed another jewel in the crown of Department of Law, Dr. Ambedkar College, Diksha Bhumi, Nagpur. The eminent and magnificently charming words of Mr. Gautam Bhatia acted as expert craftsmen for the embodiment of this jewel, his charismatic personality adding to the shine. We sincerely thank you, sir, for this brilliant talk of yours and for sensibly taking all questions which came from different participants. Mr. Gautam Bhatia surely did act like the moon, but I should not forget to acknowledge the grandeur of other numerous stars present over here, though in the audience today. I must acknowledge the presence of Shri Shankar Balveer, retired Deputy Collector, Dr. Shirish Deshpande, former HOD of PGTT Nagpur, Honorable Dr. Dilip Uke, Vice Chancellor, Maharashtra National Law University, Mumbai, Dr. Shrikant Komawar, Principal Dr. Babasaheb Ambedkar College of Law, RTMNU, and many other honorable principals and directors and various teachers from various institutions from all across the country. I am greatly thankful to you all for your gracious presence. I must mention here that nearly 400 participants across the country are attending this webinar through Zoom meeting and YouTube link. I'm really thankful to all of them. My special thanks are due to our patron, Honorable Badant Arya Nagarjun Surai Sasai, President Parampujya Dr. Babasaheb Ambedkar Smarak Samiti, Honorable Dr. Sudhir Fuljele, Secretary Parampujya Dr. Babasaheb Ambedkar Smarak Samiti, and all other respected members of Parampujya Dr. Babasaheb Ambedkar Smarak Samiti for standing behind us as a strong rock of support in every one of our endeavors. I will fail in my duties if I do not put on record special thanks to our principal, Dr. P.M. Syria, who has always been with us whenever and wherever we required her help and advice. Thank you very much, ma'am. I'm also thankful to our head of the department, Dr. H.V. Menon, for all her support and enthusiasm to conduct such programs. I'm also thankful to Dr. Varsha Deshpande for smoothly conducting the proceedings of today's program. We owe our utmost thankfulness and gratitude to all teaching and non-teaching colleagues of mine for their support for the successful accomplishment of this program. Everyone in the department really worked hard. So thank you all. I would also like to thank Shri Kamlesh Khairkar and Shri Ashish Muraskar for extending technical support for the smooth conduction of this program. Thank you so much, sir. I'm also thankful to all the students and alumni from the Department of Law and students from all other colleges for attending this webinar with all enthusiasm. Thank you, dear students. I'm also thankful to each and everyone who have helped for the accomplishment of this one-day national webinar. Thank you, one and all. Over to you, Varsha ma'am.
Thank you, Sandhya, for delivering that. Thank you, Sandhya, for delivering that noble task of Thanksgiving. With this vote of thanks, we now come to the end of this webinar, and it's the time to draw curtains on this event. But before all of us part, we would want to end this webinar with the recitation of the national anthem. The national anthem, please.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Well, with the recitation of the national anthem, we now come to the end of the proceedings in this webinar. Once again, thanking you on my personal behalf, on the institutional behalf. Gautam, thank you very, very much for having made it possible. And I think with this, we do reserve our right, if I may call it so, to trouble you at some future event to join us once again in another interesting proceeding of discussions on constitutional law with you. Thank you very much to all the participants who have joined in, and I hope it's been an enjoyable session for all of you. With this, we say goodbye from our end from Dr. Ambedkar College. Thank you very much.